behind the scenes of the medical review officer process. This afternoon, we're going to go over quite a few components in regards to the MRO, the medical review officer, and the medical review officer assistant, commonly referred to as the MRO-A. So what we will cover this afternoon will be the MRO-A, what their functions are, what their responsibilities would be, the MRO verification process. We will discuss what actually takes place during that verification process, the CCF review. The CCF is an acronym for the Federal Chain of Custody Form, also the non-DOT Chain of Custody Form. This particular presentation is geared more towards DOT medical review officer procedures. However, I will point out some of the differences in the non-DOT MRO review. It's not quite as, there are some things that really wouldn't take place in a non-DOT MRO review, but it will be very similar. So most non-DOT drug testing programs, drug-free workplace programs do require medical review of non-negative results. However, there are some things that are a bit different, and I will point that out. So, but the basic qualifications of the medical review officer, the MRO assistant, would be the same. Certain things in terms of how the donor would be contacted would be fairly similar with some small differences. So, the fatal flaws versus correctable flaws, we will cover that in terms of DOT. That is very different in terms of non-DOT. Donor contact, non-contact procedures, the donor interview, what happens during the donor interview, the results verification and reporting, the Office of Drug and Alcohol Policy Compliance, ODAPC, that is an extension, that is a department, a division of USDOT. Their position for medical review officers on CBD products and legalized marijuana. That is very important for the DOT-regulated employer to understand. So let's get started, and we're going to go ahead and move forward with this. Medical review officer qualifications. So we have a couple of things that you do need to understand about a medical review officer. Over the years, what we do run into from time to time, people really do not have, clients do not have a good understanding of what the medical review officer, what they really need to be qualified to interpret drug test results, to analyze that, to interview the donors. So, number one, it must be a medical review officer in order to even take the course, to go through the certification qualification course, must be a licensed MD or DO. They must be knowledgeable about 1, controlled substance use disorders, 2, issues related to alternative medical explanations, adulterations of urine specimens, substitutions, in other words, substituted specimens, invalid test results. Those things are learned typically during the certification classes, the qualification courses. They must be knowledgeable about current DOT guidelines and DOT regulations that are applicable to employers. And that's not as easy as it may sound. You have U.S. DOT guidelines that cover different U.S. DOT agencies. You have the Federal Motor Carrier Safety Administration. You have FAA, the Aviation Administration, the Transit Administration. You have Coast Guard. You're going to have pipeline, and you're going to have basically the railroad. You're going to have a whole host of different DOT agencies that the MROs need to be, pretty well versed in what these different agency regulations would be, and Part 40. So they need to understand not only the DOT agency guidelines, but they need to understand Part 40 as it relates to the different requirements of the laboratories, the collection process, some SAP requirements, and of course what the requirements are for the actual medical review officers. So quite a bit that the MRO is responsible to understand. When it comes to non-DOT specimen collections, typically they need to have a good basic understanding of the drug-free workplace guidelines in a particular state. There's really not a mandate for the MROs to know state law, but they do have to understand what that basic Part 40 MRO guideline would be, because that's what most states did adopt for their drug-free workplace. They have to complete training by nationally recognized MRO training organizations. There are several that are out there. They must pass an exam administered by the MRO Certification Board. They have to undergo requalification training every 5 years. They must subscribe to the Office of Drug and Alcohol Policy Compliance, again, ODAPC. This is a division of USDOT. There is a function of this called listserv for regulatory updates. All USDOT service agents are required to subscribe to this function called listserv to receive regulatory updates. Collectors, medical review officers, breath alcohol technicians, SAPs, anyone that is a service agent that functions in the drug and alcohol testing process has to subscribe to this in order to receive regulatory updates. This is mandatory. What are the basic MRO responsibilities? Number one, they have to determine if the donor has a legitimate medical explanation for a non-negative test result. That would be positive, adulterated, substituted, or invalid. It is the MRO's responsibility to determine, is there a legitimate medical explanation for this? So when this comes across the desk of the MRO, it is their responsibility to just not say, okay, this is, a definite positive, this is adulterated, substituted, invalid. They're going to interview that donor and they're going to determine, is there a legitimate medical reason? So the donor is given an opportunity to provide that. But again, we'll get a little bit more in detail as to what the MRO looks for, what they expect from that donor. The MRO is responsible to ensure the timely flow of information to employers. So again, they have a responsibility to make sure that this goes from the lab this gets from the lab to the employer in a timely manner. From the DOT perspective, particularly because these are safety-sensitive functions, they are not to get this backed up. So in other words, if these are non-negative, positive test results, if there is an issue with it, we certainly don't want the truck drivers, the pilots, anyone that is transporting the public in any shape or form. You do not want them, endangering the public because an MRO is backed up or is not addressing this quickly enough. So they are tasked with making sure you have a timely flow of this information to the employer. They must protect confidentiality. That is super important. They have to make sure that they understand all of the different functions in regards to compliance with the DOT regulations. So in other words, they want to have, they don't have to be compliance experts, but they have to have this basic understanding of the safety-sensitive functions in regards to compliance with these regulations. In addition to that, they have to make sure that they themselves function in compliance with the regulations. So they have to understand the safety-sensitive functions that the donors would perform in regards to the regulations. They have to also have a good working knowledge of the compliance that they have to perform with the regulations themselves. So again, the MRO has quite a bit to shoulder. Record-keeping requirements. For 1 year, they must retain negatives lab results, canceled drug test records for 5 years, positives or refusals to test, all of those records for 5 years. The minimal record-keeping requirement would be copy 2 of the chain of custody form with interview notes. And then drug test records are to be kept separate from patient medical records. All MRO records are to be kept confidential. So again, those are the minimal record-keeping requirements. Then we have the Medical Review Officer Assistant, again commonly referred to as the MRO-A. So what the role of the MRO-A would be is to enhance the efficiency and integrity of the MRO process, the medical review process, assist in protecting the rights of the donor during the collection process. Now, what they're referring to there, what they're saying is let's say that a specimen comes, there's some sort of issue with a test that comes across the desk of the MRO-A. What they're going to be looking at, they're going to be reviewing that chain of custody form, making sure that that specimen collector completed that correctly. In other words, did that specimen collector check the boxes correctly? Did they follow those chain of custody procedures correctly? That is their responsibility. That is one thing that the MRO-A will assist in. They're going to protect the rights of the donor. So if a specimen collector did a sloppy job and did not handle that specimen collection correctly, the MRO-A can certainly detect that and can make sure that that information is passed along to the medical review officer. It is very important that the MRO-A understands all aspects of the regulations. Not a regulated position. However, certification is recommended. Professional certification programs are available with renewals every 3 years. So with NTA, with our clients, most often they tend to interact most often with our MRO-As for preliminary information. They will get calls from the medical review officer, but they do find that they will get calls from our medical review officer assistants as well. So it's important to understand that there is a difference with that. So the basic responsibilities. They assist the MRO whenever possible, whenever needed. They review the chain of custody forms. They're looking for did they check the right temperature box? Did they check everything correctly? Was everything completed? They investigate and correct problems. They request affidavits if needed. They provide feedback to employers, collectors, laboratories. They consult and report to the Office of Drug and Alcohol Policy Compliance, ODAPC, anything that was not done correctly or anything that is required to be reported to ODAPC. The MRO assistant can do that. Report laboratory test results that required corrective action. Contact donors to schedule the MRO review or interview. So there is a big difference that I want to point out here because we do have a little bit of confusion that comes up from time to time on this. The MRO assistant does not contact the donor and do the interview. The MRO assistant will contact the donor to schedule the medical review officer interview. It is mandatory that the medical review officer interview the donor. The medical review officer assistant is the one that will schedule that interview. I want to make that clear because I think there's some confusion on that from time to time. They obtain copy 1, which is the original copy of the chain of custody form from the laboratory. They report a negative dilute that does not require a recollect under direct observation. We'll talk about that later on. They ensure the timely flow of test results, including split specimens. They transmit results to the DER, the designated employer representative. Each employer must have a designated employer representative. That's the primary contact that handles the drug testing program, that receives drug testing results. They transmit the results to the DER after the MRO has completed the donor interview. The MROA must always protect the confidentiality of the drug testing information. What does the MROA look for on the chain of custody form? They are looking for matching the specimen ID number on the chain of custody form and the lab report. That is very important. You want to make sure that we've got the right chain of custody form coming in and it's matching to the right lab report. Super important. They are looking to make sure that the collector checked the correct testing authority. And when we say testing authority, we're talking about is it DOT, going down into the different DOT agencies. Reason for testing, pre-employment, post-accident, reasonable cause, random. Is that box checked? Was the temperature box checked? Did the collector print their name, sign their name? Did the donor print their name, sign their name? In the event of a return to duty or follow-up test, particularly under DOT, this is where this is very important, did they check the observed collection box? Did they make notes in the remarks section as required in the event of a dual collection if temp is out of range or adulterated specimens? When we have collections if there's a collection where the specimen is brought out to the collector and it is cold or there is something wrong with it, they are supposed to immediately collect another specimen under direct observation. And they are sending in 2 specimens. It's called a dual collection. And they have to make notes in the remarks section, cross-referencing the specimen ID numbers. Very important. So this is something that's covered in the collection training. So the MROA is going to look for that on those chain of custody forms. So again, very important. Again, a lot of information. Again, this presentation is getting into the nuts and bolts of some of the key components, some of the things that goes on behind the scenes. So a lot of information with this. This is some of the things that they're going to be looking for. Now, there are some things that the MROA, that the assistant, cannot do. These are things that the medical review officer has to do, okay? So number one, what they cannot do is gather medical information. They cannot do that. Only the medical review officer can do that. They cannot determine legitimate medical explanations for laboratory confirmed positives, adulterated, substituted, or invalid drug tests. Only the MRO can do that. They cannot conduct donor interviews. They can only schedule those interviews. They cannot be involved with the shy bladder evaluation other than assisting the MRO with the paperwork. That's all they can do. They cannot cancel a drug test. Only the MRO has the authority to do that. So there are some things that the MROA cannot do. So you want to make sure that you understand the difference with that. More ways that a medical review officer assistant can assist. You have 2 types of flaws. These are errors that can cause a lot of problems with drug tests, and they are called correctable flaws and fatal flaws. Fatal flaws, which come from Part 40, 199, you basically have 4. If Step 4 on the chain of custody form, which is where the collector signs their name and prints their name, if that is not completed, if the specimen ID number on the form and the bottle seals do not match, if the collector did not collect a sufficient amount of urine for the primary specimen bottle and the split cannot be redesignated, if the bottle seals are broken or torn, if there's no chain of custody form with the specimens or the specimens go into the lab without a form, or in the event of dual collections, they had 2 collections with only 1 form, all of those are considered fatal flaws. Fatal flaws cannot be corrected. They must be canceled Error correction training has to be conducted. And what that means is the specimen collector, the laboratory, is going to send a notice to the medical review officer that they've been canceled. And then the MRO is going to send a notice to the specimen collector that they have to complete error correction training within 30 days. The MRO assistant can send that to the collector for the MRO, so they can do that. It has to come back to the MRO within 30 days, or it's illegal for that collector to continue collecting. So this is very important. So during specimen collector training, whoever the instructor is needs to cover that very, very carefully. Correctable flaws. These are errors that are committed. They have a temperature box that's not checked. You have collector signature only missing. You have the employee signature missing. All of the correctable flaws, the MROA can send affidavits, but if not received, the test has to be canceled, and only the MRO can do that. So with the correctable flaws, you have a situation where the MROA can send the affidavits out. We can fix this and these situations, but if we don't get this, then we have to cancel a test, and only the MRO can do that. So again, this is kind of a little bit of a heavy regulatory page here, but these are things that the MRO can assist with. So making contact. So what happens? The MROA, when you get a non-negative result in from the laboratory, the MROA initially will make 3 attempts to contact the donor within 24 hours to get that interview scheduled with the MRO. If that does not happen, then they will contact the DER if the donor number is not in service or is the wrong number. Then contact the DER if unable to reach the donor within 24 hours. So either way, that's what's going to happen from the MROA. So the DER will then contact the donor, make 3 attempts within 24 hours of the call from the MROA, contact the donor and inform them that they have 72 hours to contact the MRO, provide the MRO office with the contact time and date. If unable to locate donor, inform the MRO office. And then at that point, if the MRO does not hear from the donor within 10 days from that contact date, then it will be reported as a no contact positive. So this is kind of the flow chart. If you've ever wondered, where that time starts, how many times does this take place, you have, again, the MROA, 3 initial contacts within 24 hours, contacts the DER. If the number is not in service or a wrong number, and then, of course, you've got that 24-hour period, then the DER is going to try 3 times within 24 hours, then contacts the donor. If they get them, inform them they have 72 hours to contact the MRO, lets the MRO office know the contact time and date, or if they're unable to locate the donor, inform the MRO office, and then there's 10 more days at that point. So it can stretch out for quite a bit of time. And so, again, if there's a 10-day period from the date of the lab result and there's been no contact, then it automatically transitions into a positive. Contact concerns. These are things that we run into quite often. These are concerns, so let me review this very carefully. Number 1, don't assume the worst. So, again, most of the time, negatives are back within, depending on the collector, depending on the laboratory, how quickly the lab's turning around, the time of day, the courier service. It can be anywhere between 24 to 72 hours to get a negative test result back. Positives typically take longer. So clients tend to get a little anxious if they're not hearing anything back. Don't assume the worst. If the result is taking longer than normal, there could be several reasons. Number one, the MRO office does not have a copy of the chain of custody form. This is required by DOT before the test result can be released. I want to make a comment here. Non-DOT test results do not require a copy two of the chain of custody form. If you've ever taken a look, or if you're a specimen collector, the donor's signature is on copy one, so they really don't have to have that separate copy. So we're really not chasing around a copy two with non-DOT test results. So that sometimes moves a little bit quicker. But we must have copy two in order to release a DOT test result. So that's usually the primary culprit if there's a holdup with that. The specimen could be in further testing at the laboratory. This means they're trying to isolate certain drug metabolites at the laboratory, and that can be very frustrating because this can take sometimes up to 14 days. We have seen that happen. The medical review office may be in the process of contacting the donor, pharmacist, or physicians to verify prescriptions or medical information, and this can take time. They're trying to wait for return phone calls, or trying to reach a physician, trying to reach a pharmacist, trying to reach a donor or a DER. So it can take some time for that. So what to do? Contact the MRO office. They can determine the status of the test result. Where is it in that process? We do have clients, sometimes they try to call the laboratory. The laboratory typically isn't going to be able to really give you a lot of information. It's best to contact the MRO office that you have contracted with, and they can usually tell you, is it in further testing? Are they missing copy two of the chain of custody form? Or are they in some sort of process of verification? So just give your MRO a call. So let's talk a little bit about the MRO verification, and we'll also touch on HIPAA. Most people do not realize that HIPAA does not apply during the MRO verification process. So that does go out the window a good bit with this. The MRO does not need and must not attempt to obtain a donor's permission to verify drug test results, for consultation with a prescribing physician or pharmacist, to report results and fitness for duty concerns to employers, or to consult with substance abuse professionals. So these are all important things to keep in mind. So a little bit different when we're dealing with drug test results and HIPAA. MRO verification, the interview. Very important things to understand. Number one, the MRO is required. Now this is DOT, non-DOT from a legal perspective. Is required to personally speak with the donor. The MRO is required to explain the verification interview process. They're required to explain that the employer will be notified of verified results and medical information that will affect performance of safety-sensitive duties. So one thing to understand is it's not just a drug test result issue. If at some point during this MRO interview, the medical review officer learns of a medical condition or learns any other medical information that could have an impact on that individual's ability to perform safety-sensitive duties, that could be reported as well to the employer. So, there could be some things that do go above and beyond the MRO, the drug testing piece of this. So it's important to realize that as well. They are required to notify of specific lab results. They have to request an explanation, and the donor does have the burden of proof. They are required to notify of requirement for further medical evaluation is indicated. So the MRO certainly has the right, and they often do ask the donor to submit to some sort of further medical evaluation or submit further documentation if they feel they need that as part of that interview verification process. So that is why it can take time. It's not just a matter of, do you have a prescription for this, or, tell me what has been going on. They may need to send that donor for further evaluations, or they may need to get further documentation, which again can take some time. So this can certainly draw out into a little bit of a lengthy process. So this is a flow chart. It shows you, this is really kind of that chain of custody process. So the donor provides the specimen to the collector, who then prepares the shipment for the lab. The courier forwards the specimen to the lab. The collector forwards the specimen to the lab via secure courier service. The lab reports the negative results to the MRO, with the results reported to the DER. Okay, so that's pretty straightforward there. Positive results then go to the MRO, who interviews the donor for medical explanations. It can take 2+ days. Then the MRO is going to report verified positives to not just the employer, but to currently the FMCSA Drug and Alcohol Clearinghouse at this point in time. And then, of course, refusals are going to be reported to the DER. Those have to be reported to the clearinghouse as well. All other DOT agencies do not have a clearinghouse. The MRO doesn't report anything into the clearinghouse other than FMCSA. So it gives you a nice flow chart that you can review here. And, of course, this PowerPoint is available if anyone would want it. MRO verification. Let's talk about prescribed medications. Verification of prescriptions are legally and medically necessary. There's currently no guidance from ODAPC on the length of time a prescription is valid after issuance. So what they're basically saying is if someone has an older prescription, there's really not a whole lot in the MRO manual from ODAPC that talks about that. So this could be a little subjective from MRO to MRO. The medical review officer may request that the donor contact the prescribing provider, have that provider make contact with the MRO within 5 days of the interview to discuss safety concerns about a prescription's effect on the donor's ability to perform safety-sensitive functions. Legitimate treatment examples. These are lab-confirmed positives, MRO-confirmed negatives. So this is when you would get, we have questions often when laboratory summaries come out and they do not match. They will have a positive on a laboratory summary. However, the client will see a positive on the summary, but they will say, well, we did not receive any positives. Well, that's because they were overturned as a confirmed negative because there was a legitimate prescription. So legitimate treatment examples, legitimate prescriptions, would be codeine prescriptions for coughing and pain, narcotic analgesics prescribed for pain, prescribed tetrahydrocannabinol for AIDS, cancer, anorexia, and that would tend to show up under THC. Prescribed cocaine as a topical or an anesthetic. And again, these are all within therapeutic levels that would not affect the ability to perform safety-sensitive functions. This is what the MRO is trained in evaluating. So let's talk a little bit about this 5-day waiting for prescription review. So let's say the donor has a legitimate prescription for a controlled dangerous substance, a CDS. So this is a substance that is a pretty heavy-duty controlled substance. For whatever reason, they have a prescription for that. immediately report verified so what the MRO will do is immediately report a verified negative result to the employer, but will also report that with a qualifier, with a safety concern. This is when the donor will be allowed up to 5 days from the date of the verified negative result for the prescribing physician to contact the MRO to determine if the medication can be changed to one that does not make the donor medically unqualified or pose a significant safety risk. So you may find that this happens more and more. So the donor very well, so if you could potentially have a situation where you receive a report, you have a verified negative, but the MRO says there is a safety concern, and normally they will tell you that the donor has been given up to 5 days to have their prescribing physician contact the MRO to determine if the medication can be changed to something that does not make the donor medically unqualified or pose as much of a safety risk because it's considered a controlled dangerous substance. This is something that happened, this came into place in January 2018. So again, this is something that you may run into. So the MRO is always responsible to raise these fitness for duty considerations. The donor's explanation will remain confidential if there is a valid medical explanation and no fitness for duty considerations. The 5-day rule does not apply, and the employer is notified immediately if the donor declines to speak to the MRO, the donor discloses a medical condition that would result in the donor being disqualified, or the MRO has spoken with the prescribing physician and the matter remains unresolved. So this means that the MRO very well may contact you and say, okay, the 5-day rule isn't going to apply. We have an issue here, and you're going to have to make a fitness for duty decision. So again, this can get a little complex. So let's talk about some of these drugs that are on the DOT drug screen. Of course, you have marijuana, you have cocaine, amphetamines, you have opiates, and then which you have the amphetamines breaks out into several different categories. Then you have PCP, and of course you have the opioids in that too. The opioids breaks out into a number of different prescription drugs, but amphetamines, you have legitimate medical conditions that may warrant the amphetamine prescription. Methamphetamines present on the lab results in a different way. Certain levels can be consistent with Vicks inhalers, otherwise it's consistent with illicit drugs. The trained MROs ascertain this on the lab results. So again, that's not something that the employer would do. This is something your MRO would determine based on those lab results. And you do have certain medical conditions for which that donor may have an amphetamine prescription. And again, the MRO is going to determine what is this condition. They're going to look at those therapeutic levels. Is it safe for them to perform safety-sensitive functions? Again, and they're going to be looking at all of that. Opioids are the same way. So you have 6-acetylmorphine, that breaks out into that. It's always verified positive. That's never going to change. That would be heroin. Morphine or codeine greater than the 15,000 nanogram ml is going to be verified negative with a legitimate medical explanation such as a prescription. Poppy seeds are not legitimate. Verified positive with no prescription or clinical evidence of use. So again, that's pretty straightforward with that. Morphine or codeine less than 15,000 nanogram ml, the MRO is going to have the burden of proof to show unauthorized use. So those are just some basic guidelines with that. Pretty straightforward again. Marijuana. Some important things to understand about marijuana. With the advent of the legalization of marijuana in a number of states across the country, and we have just a plethora of CBD and hemp products available, From a USDOT perspective, that is not accepted as a legitimate medical explanation for any reason for DOT mandated testing. So the MRO must not verify a DOT test as negative regardless of any state law. CBD or hemp products are not considered as a valid explanation for a positive marijuana test. It does not matter. It does not matter if they have been advised by a physician. It absolutely doesn't matter. There are two handouts, press releases from ODAPC, one for medical marijuana, one for the CBD and hemp products that we are certainly glad to send to any client that you can distribute amongst your employees. That would be very important for them to understand. So again, if you have DOT-regulated employees, it does not matter what the state laws are in regards to medical marijuana. It does not matter if they have a prescription for it. If it shows up with the MRO, he is going to verify that as a positive. Same thing for CBD or hemp products. For non-DOT employees, where this is concerned, the MRO will most likely verify it as positive, but it will end up with the employer, and you will revert back to whatever your policy is in regards to your state laws. MROs tend to steer clear of this at the current time until something changes with it. Now, there is a different category. You have THCV testing. This is a different metabolite for the THCV metabolites, GCMS testing at the lab. The presence indicates herbal versus pharmaceutical THC, which is Marinol, which is an actual pharmaceutical form of Marinol that is used for AIDS, cancer, anorexia. If that is present, that would be acceptable in terms of an MRO. So the absence does not disprove medical marijuana, but that is something that, these are things you need to be very cognizant of and very aware of in terms of medical marijuana and the CBD products. But again, if it's a pharmaceutical that shows up, that's a whole different animal. Let's talk about negative dilute specimens. If a specimen comes back as a negative dilute, the MRO verification, you've got two options. Recollect as soon as possible if it is written in the employer's policy, but it has to be written in the policy if you want to do that. If it's not in the policy, then you really cannot do that. The second option would be recollect under direct observation if the creatinine levels are less than 5 milligrams. The MRO will inform the DER of this. So again, those would be the two options on negative dilutes. Invalid specimens. You have acceptable explanations and you have unacceptable explanations. So the test is canceled, remarked invalid results. No further action needed unless a negative result is necessary, such as in the event of pre-employment, return to duty follow-up testing. If the negative result is required, MRO verification is based on clinical evidence. Unacceptable explanation, test canceled, remarked invalid result, recollect under direct observation, notify employer immediately if the specimen produces another invalid result for a different reason. The donor is not contacted. So sometimes we do run across these, and you may see these from time to time. Examination negative test result required. If the MRO makes a determination based on clinical evidence of illicit drug use, long-term medical condition that affects ability to produce a valid specimen, face-to-face medical exam is required. So in that case, if the MRO is long distance, they would go to a PCP or they would be referred to a local MRO. Alternative testing is allowed, blood or hair. Verification would be negative if no clinical evidence of drug use. Test canceled if clinical evidence of drug use. Refusal to test if donor fails to undergo the examination. So remember, early on, I said the MRO could get into ordering medical evaluations and a whole host of things. This would be a piece of it here. Adulterated specimens. The donor must demonstrate that the adulterant, soap, bleach, surfactants, anything, entered the system through physiologic, which means appropriate or normal means. So they would have to demonstrate, to the MRO somehow. It was an accident. I did not intentionally do this. So, that would be a hard sell, to get this, to convince an MRO that you somehow got bleach into a specimen. So that would be between the donor and the MRO. The MRO may direct a physician evaluation, someone who has expertise in the medical issue raised. The verification would occur. Test is canceled. Inform the Office of Drug and Alcohol Policy Compliance for an acceptable explanation. Refusal to test. And adulterated if no acceptable explanation or the donor admits. So those are the two options when you have adulterated specimens. So you're going to have one of two. So if there's some way, so if a lab report comes back as adulterated, and the MRO through this physician evaluation or the donor can demonstrate that something truly appropriate happened, the test would be canceled, and then ODAPC is informed. Otherwise, it's going to be reported as a refusal to test or an adulterated with no acceptable explanation, or perhaps the donor would just flat out admit that. Substituted specimens, it's pretty much the same thing. Donor has to demonstrate the ability to produce urine through normal physiologic means. The test would be canceled and inform ODAPC if an acceptable explanation is found. If not, it's going to be reported as a refusal to test as a substituted specimen. That's pretty straightforward. And again, this is a chart that's very helpful. It gives you the creatinine and specific gravity values and what would happen with the dilutes, invalids, and substituted. So that's a pretty helpful chart. And again, this PowerPoint is available if anyone would like it as a reference guide. Shy bladder. Now, this does happen, and just to kind of give you a very quick overview, typically for DOT purposes, what they have to do when a DOT employee goes in, the collectors are trained, they have to give the donor up to 3 hours and up to 40 fluid ounces to produce 45 ml. If it is a non-DOT test, most of the time, most drug-free workplace programs and most state guidelines have adopted Part 40 guidelines, so they will mandate the same. So in all DOT cases and in most drug-free workplace programs, the employee is going to be asked to wait 3 hours to come up with the 45 ml, and they will be offered up to 40 fluid ounces during that period. And at the end of the 3-hour period, if they still are unable to produce one full 45 ml void, it has to be one full void, then the collector is to document on the chain of custody form, insufficient specimen reported to DER. They will send a copy to the medical review officer, who is then waiting for the results from a medical evaluation. So if this is a DOT test particularly, it's super important. So some of the explanations could be, I have kidney stones. So the MRO could recommend a local MRO or a urologist for evaluation, and then you provide a letter from a PCP stating the donor was unable to void due to urinary tract infection. That's very, very common, okay? So if they're told that, the MRO will request documentation supporting that diagnosis. If it's obtained, that's great. The test is pushed on through. If not, the test will be verified as a refusal to test, and reported to the DER with all of the subsequent consequences. So they're pretty strict with the shy bladder because it can be used. What they're trying to do is prevent that from being used as an evasive tactic to get out of a drug test that given day because they know they can't pass the test. So they have to have a legitimate medical reason for not being able to produce 45 ml within a 3-hour period. Split specimens, they're offered for verified positive, adulterated, or substituted results. The donor has 72 hours to request the split specimen testing. That's after they've had their interview. Upon request, the MRO immediately arranges for the specimen transfer from Lab A to Lab B. The donor is not required to pay before the test takes place. However, if an employer wants to have in their policy that they have to reimburse the employer if it does come back differently, that's fine. That's between you and the employee. But the MRO cannot require the donor to pay up front. The initial non-negative or positive verification is immediately reported to the employer. DOT does not allow waiting on the split test result, so you can't require a stand down or anything like that. The split specimen verification is reconfirmed when Lab B reconfirms result of Lab A. So failed to reconfirm and test canceled. It kind of goes through the whole process here. If Lab B fails to reconfirm Lab A, Lab B fails to reconfirm primary results of Lab A, and Lab B results are invalid, adulterated, or substituted. MRO verification will proceed with Lab B. ODAPC will be notified, test canceled, and immediately retest under direct observation if split is unavailable for retesting, and then notify ODAPC. Very important, employer action against donor is reversed when failed to reconfirm and test canceled takes place. So if you get a notice from the MRO, from the medical review officer, if you get a report from the MRO that says failed to reconfirm, test canceled, any action you've taken against the employer has to be reversed. Non-negative verification without donor interview. So let's say that you've received a positive test result on a donor, and we have this happen fairly often, unfortunately. So we have forwarded over a positive test result to the DER, and it's because of a couple of reasons. So number one, the donor declined to discuss the test. The donor has not contacted the MRO, and more than 72 hours have passed since the DER successfully contacted the donor. The MRO and DER have been unable to contact the donor within 10 days of the date when the MRO received the confirmed test result. If those three things have happened, the test is then going to be verified as a positive. So then at that point, if it's FMCSA, it's reported into the clearinghouse. All the subsequent disciplinary actions take place. So, can those be changed? Yes, they can. The MRO may reopen a verification that was made without an interview if the donor can produce documentation of serious injury, illness, or circumstances that precluded that contact. So if they can produce legitimate documentation of those things, anything that precluded contact, and they can produce that within 60 days, the MRO may change verification, and that does happen. If more than 60 days have passed, the MRO must contact ODAPC to get permission before changing the verification. The MRO can also reopen a verification that was made without an interview due to a lab error or if there was an administrative error made by an MRO. Should a verified non-negative test result be overturned and verified negative, any reports into the FMCSA clearinghouse would need to be reversed. So a lot can happen if anything like that is overturned. So to wrap up today's presentation, we covered the basic key components of what the MRO and the MRO assistant functions are, what they normally encounter. However, this presentation certainly cannot cover all components of the training they both receive. It also cannot cover all potential situations and circumstances that can occur for the donor and the employer. There are so many things that can happen and that do occur on a regular basis. Please contact us at NTA. We have many helpful ODAPC handouts on various aspects of the different DOT drug and alcohol testing programs, about MROs, SAPs, handouts for employees and for the DER. If you have non-DOT MRO questions, please feel free to contact us. Thank you for viewing our presentation. Feel free to contact me. My name is Kim Clater, the Compliance Director. My contact information or any of our customer service representatives would be glad to help you. Thank you for viewing our presentation this afternoon, and have a great day.